Thank you, Mr. Speaker. C'est mon honneur aujourd'hui de prendre la parole pour faire cette question de privilège sur les questions de les clôtures des débats. I'm rising at my first opportunity on this question of privilege, Mr. Speaker, given that between the speech from the throne in October and when we adjourned June 20th, there had been 21 occasions in which closure of debate occurred, and I maintain that the exercise of my rights and the rights of my colleagues in this place have been obstructed, undermined, and impeded by the unprecedented use of time allocations in the second session of the 41st Parliament. Mr. Speaker, in presenting this fairly legal argument to you, I propose to leave out page numbers and citations because I've prepared a written version of this for your office, and I hope that will be acceptable to you, that I skip page numbers in this presentation. Hansard may not have the numbers of debates, but I hope that there's enough context so that people can find them. I believe this excessive use of what's often called guillotine measures is a violation of the rights of all members of Parliament, but I'd like to stress that there's a disproportionate impact on members such as myself, who are within either smaller parties, that is less than 12 members, or who sit actually as independents, because in the roster of recognizing people in their speaker slot, quite often those of us in the smaller parties or independents simply never get to speak to the bills at all. My question, Mr. Speaker, bears directly on what your predecessor said in this place on December 10th of 2009, quote, "The fundamental right of the House of Commons is to hold the government to account for its action, an indisputable privilege and, in fact, an obligation." In the autumn of 2011, in a ruling concerning the member for Mount Royal, Mr. Speaker, you yourself said that to constitute a prima facie case in regards matters of obstruction, interference, molestation, or intimidation, you need to, quote, "assess whether or not the member's ability to fulfill his parliamentary activities has been undermined." At that moment, in the same debates, you had the occasion to reflect, quote, on the chair's primordial concern for the preservation of the privilege of all members. And you added, quote, "As your Speaker, one of my principal responsibilities is to ensure the rights and privileges of members are safeguarded, and this is a responsibility I take very seriously," close quote. Mr. Speaker, I now have occasion to turn to other words that will guide us in this matter from the Supreme Court of Canada in the Vade decision. In the words of Mr. Justice Binney, speaking for the court, he outlined the scope of parliamentary responsibility, parliamentary privilege for the management of employees, and said parliamentary privilege is defined by the degree of autonomy necessary to perform Parliament's constitutional function. And he went on to say at paragraph 41 of that Supreme Court of Canada judgment, quote, "Similarly, Mango defines privilege in part as, inner quote, the necessary immunity that the law provides for members of Parliament and for members of the legislatures of each of the provinces and 2 territories in order for these legislators to do their legislative work." I'm going to repeat that and emphasize it, because although the Vade decision was on a different fact set, Mr. Justice Binney spoke to our core responsibility as parliamentarians when he said that we must be able, as legislators, to do our legislative work. Mr. Justice Binney continued in Vade to say, quote, "To the question necessary in relation to what, therefore the answer is necessary to protect legislatures in the discharge of their legislative and deliberative functions, and the Legislative Assembly's work in holding the government to account for the conduct of the nation's business." To the same effect, and I'm still quoting from Mr. Justice Binney, see Marlowe, and Montpetit, where privilege is defined as, quote, "the rights and immunities that are deemed necessary for the House of Commons as an institution and its members, as representatives of the electorate, to fulfill their functions," close quote. Mr. Justice Binney, by the way, went on to find further references in support of these principles from Bourneau's parliamentary procedure and practice. Now, these are fundamental points. The purpose of us being here as parliamentarians is to hold the government to account. It is obvious that no legislative assembly would be able to discharge its duties with efficiency or to assure its independence and dignity unless it had adequate powers to protect itself and its members and officials in the exercise of these functions. Finally, Mr. Justice Binney, again for the Court, said at paragraph 62 on the subject of parliamentary functions, in ruling that some employees would be covered by privilege, found that coverage only if a connection was found that coverage existed, only if a connection was established between the category of employees and the exercise by the House of its functions as a legislative and deliberative body, including its role in holding the government to account. As I said earlier, Mr. Speaker, this approach was supported by your immediate predecessor, when, of course, at December 10th, 2009 ruling, again, the Speaker of the House, the Honourable Peter Milliken, said one of his principal duties is to safeguard the rights and privileges of members and of the House, including the fundamental right of the House of Commons to hold the government to account for its actions, an indisputable privilege and, in fact, an obligation. It is, therefore, Mr. Speaker, a fundamental principle of Westminster parliamentary democracy that the most important role of members of Parliament, and in fact a constitutional right and responsibility for us as members, is, again, to repeat, to hold the government to account. In this connection, Mr. Speaker, the events in this House that we have witnessed before we adjourned June 20th, 2014, clearly demonstrate that the House and its members have been deprived of fulfilling constitutional rights, our privilege, and our obligation to hold the government to account because of the imposition of intemperate and unrestrained guillotine measures in reference to a number of bills. Over 21 times closure was used. And Mr. Speaker, only in the interest of time, I'm going to read out the numbers of the bills and not their full description, but bills C2, C4, C6, C7, C13, C18, C20, C22, C23, C24, C25, and C27, C31, C32, C33, and C36 were all instances where closure of debate was used, and in many of the instances I just read out, and in the written argument I've presented to Mr. Speaker, closure of debate occurred at second reading, again at report stage, and again at third reading. So the limitation of debates was extreme. A close examination of the guillotine measures imposed by the government demonstrate that the citizens of Canada have been unable to have their elected representatives adequately debate the various and complex issues central to these bills in order to hold the government to account. That members of Parliament have been deprived and prevented from adequately debating these measures through 21 separate motions for time allocation in this session alone undermines our ability to perform our parliamentary duties. In particular, I want again to highlight the effect the guillotine motions have on my ability as a representative of a smaller party, the Green Party. We don't have 12 seats in the House yet, and as a result, we're in the last roster to be recognized once all other parties have spoken numerous times. Quite often, there is never an opportunity for members in my position, nor for independent members of Parliament, to be able to properly represent our constituents. Again, I shouldn't have to repeat this, Mr. Speaker, and certainly you are aware that in protecting our rights, as you must as Speaker, in this place we are all equals, regardless of how large our parties are. And as a member of Parliament, as voters in Canada are all equal, so too do I, as a member of Parliament, have an equal right and responsibility to represent the concerns of my constituents in this place, equal to any other member in this place. So as speaking time allotted to members of small parties and independents is placed late in the debates, we quite often are not able to address these measures in the House. This would be fair if we always reach the point in the debates where independents get recognized, but that doesn't happen with closure of debates. My constituents are deprived of their right to have their concerns adequately voiced in the House. As you know, Mr. Speaker, political parties aren't even referenced in our Constitution, and I regard the excessive power of political parties over processes in this place in general to deprive constituents of equal representation in the House of Commons. But, Mr. Speaker, in the circumstances, the additional closure on debates continues to particularly disadvantage those constituents whose members of Parliament are not with one of the larger parties. In the autumn of 2011, in your ruling considering the member of Mount Royal and his question of privilege, you said that one of your responsibilities that you take very seriously is to ensure that the rights and privileges of members are safeguarded. The principal right of the House and its members and their privilege is to hold the government to account. In fact, it is an obligation according to your immediate predecessor. Now, in order to hold the government to account, we require the ability and the freedom to speak in the House without being trammeled and without measures that undermine the member's ability to fulfill his or her parliamentary functions. For as the British Joint Committee report pointed out, without this protection, members would be handicapped in performing their parliamentary duties, and the authority of Parliament itself in confronting the executive and as a forum for expressing the anxieties of citizens would be correspondingly diminished. To hold the government to account is the raison d'etre of Parliament. It is not only a right and privilege of members and of this House, but a duty of Parliament and its members to hold the government to account for the conduct of the nation's business. Holding the government to account is the essence of why we are here.
C'est pour cela que nous sommes ici. C'est une fonction constitutionnelle. Pour citer même les marketeurs, c'est notre fonction numéro 1. Nous devons examiner des projets de loi et pour demander des comptes au gouvernement, nous soulevons des questions de privilège. Ce privilège nous a été refusé étant donné l'utilisation extrême de l'attribution de temps. 21 fois dans cette session uniquement. Cette utilisation du bâillon est sans précédent dans l'histoire du Canada. Et cela vous empêche, vous, à titre de président, de protéger nos droits et nos privilèges à titre de membre, comme vous l'avez dit à plusieurs reprises. C'est votre responsabilité, vous la prenez très au sérieux. Mais ces motions de clôture vous empêchent de nous protéger. Et donc, ça diminue le rôle du président, un rôle qui a été honoré depuis les débuts de notre histoire. Vous avez, à l'automne 2011, j'ai oublié le numéro de la page 4396, je crois, quand vous avez eu l'occasion de vous prononcer sur la préoccupation du président, le souci primordial de la présidence pour la préservation des privilèges des députés, vous avez dit qu'en tant que président, l'une de vos principales responsabilités, c'était de veiller à protéger les droits et privilèges des députés, et c'est une responsabilité que vous preniez très au sérieux. Fin de la citation. Donc, priver les députés de leurs droits et privilèges de demander des comptes au gouvernement, c'est inacceptable, c'est contre la raison d'être du Parlement et ça va à l'encontre de la fonction et du rôle du président de protéger les privilèges. Et donc, en conclusion, j'estime, Monsieur le Président, que l'utilisation illimitée des attributions de temps de ce gouvernement constitue un cas prima facie d'atteinte aux privilèges de tous les députés de cette Chambre, surtout ceux qui sont indépendants ou comme moi, qui représentent un des partis qui a moins de 12 membres. Monsieur le Président, j'apprécie le temps que vous m'avez accordé. J'espère que vous allez vous prononcer en faveur de cette question de privilège, qu'il s'agit effectivement d'un cas prima facie d'atteinte aux privilèges de tous les députés de cette Chambre.